In the modern real estate industry, the Multiple Listing Service, or MLS, operates as the central nervous system. It is the localized database where every single home for sale is logged and tracked. If an agent loses access, they cannot see the active market. Their business stops. Agents can't simply pay their local office for a login. Instead, they face the three-way agreement, a mandate requiring simultaneous dues to their local, state, and National Association of Realtors. They are forced to purchase all three membership layers to access the data. This structure ensures that the only way to see the local market is by committing to all three association layers. It creates a mandatory all-in requirement for the data needed to do the job. Over the last 18 months, that all-in model has faced a massive wave of resistance. Real estate agents began filing lawsuits against the National Association of Realtors, or NAR, with the goal of separating membership from data access. One significant federal case was filed in Louisiana. A group of agents, led by Carla DeYoung, sued local associations and the AAR directly. Their core allegation was that tying MLS access to three mandatory memberships is anti-competitive. They argued it creates illegal barriers for small businesses and ultimately results in higher costs for consumers. This Louisiana case was a direct legal strike. It was designed to see if the three-way agreement could survive a challenge under federal antitrust law. But that attempt to break the bundle through the federal court system has so far failed. District Court Judge Shelley D. Dick recently granted a motion to dismiss the federal antitrust charges against AAR and local associations in the Louisiana case. Claims under the Clayton Antitrust Act were dismissed with prejudice. Those charges are permanently dead. However, other charges, including Sherman Act claims, were dismissed without prejudice, giving plaintiffs a 21-day window to try again. While the door remains slightly open for state-level claims, the NAR successfully protected its core membership model from a major federal takedown. Following the ruling, the NAR issued a statement defending their local marketplaces as competitive and beneficial for consumers. But a shift was hidden in their legal defense. The NAR pointed to recent updates in their official handbook, which state that local MLSs have the authority to determine their own access rules. By emphasizing local control, the national organization is effectively moving the legal responsibility for these rules away from the national office and down to the local databases. To win the federal case, the NAR argued they weren't the ones forcing the bundle, shifting the final say over data access directly back to the local associations. Now, local leaders are beginning to use that same loophole. Afraid of being the next targets for litigation, many are moving to change their rules before they are forced to in court. In Alabama, the state association took a public stand, formally asking the NAR CEO to make national membership optional for their agents. Similar shifts are happening in major cities. Chicagoland's MRED MLS recently voted to make association membership entirely optional for its participants. Even though the federal lawsuit was dismissed, the threat of legal action is causing the actual data holders to voluntarily dismantle the mandatory bundle. These state-by-state changes are quickly becoming the new industry standard. A recent survey of real estate executives found that 70% now expect a la carte membership models to emerge this year. Years of legal pressure and a changing reputation have altered what agents are willing to accept. Many no longer see the value in a three-tiered fee structure just to see what homes are for sale. The Louisiana ruling shows that ending this system in federal court is a slow, difficult process. But as local associations begin to drop the requirements on their own, the era of the forced real estate bundle is fading, replaced by a model where agents only pay for the access they actually need.